Hello everyone, my name is Laurence Gendelman and I'm the president of Gendelman Law Group. We're a law firm out in Denver, Colorado. We do probate, trust, and family law specifically. Today we're going to be talking a little bit about settlement and the power of settlement. So I'm going to start with a Lincoln quote that some of you may have heard before, but the quote goes, "Discourage litigation, persuade your neighbors to compromise whenever you can. And as a peacemaker, the lawyer has the opportunity of being a good man. There will still be enough business." Here today at the Colorado State Capitol, where I'll be speaking. You have to click with your lawyer. When you meet them, there should be...
So one of the ways that I give back to the community is by educating people about the ways that they can understand the role of their lawyers.
So the idea here is that settlement helps people. Coming to agreement helps people. The way that I tend to approach cases and tend to encourage my clients to approach cases and that decision of, do we settle, do we mediate, do we go to trial, what do we do, is you approach your case almost like you would approach a medical issue. A legal issue and a medical issue in some respects can be approached similarly. When you have a medical issue, you go to the doctor. You don't start with the surgeon. You'll typically go to your general practitioner or perhaps a specialist, and they'll tell you to go about some course of action, which might include, let's say, physical therapy if it's like an orthopedic issue, or chiropractics, and perhaps some medication along the way. Surgery is at the very end. That's when nothing else works, when you've excised every other less intrusive, less invasive, less intense, less expensive option, and still nothing is working, and that's when you do surgery. Law can be looked at the same way, and I think should be looked at by clients the same way. Trial, or going to a contested hearing, is that's the last hope. That's when you've tried everything else to try to resolve your dispute. It's not about going to court and trying to be right or trying to even win for that matter. That's your last hope in trying to get what you need to be able to move on and end your lawsuit that you're involved in. So a couple reasons I'm going to talk about as to why to settle. First of all, time. When you're in a case, when you're in a civil case or when you're in a domestic relations case or a probate case, the time period can be very long, from the time that you file to getting into your first hearing to going through discovery and then getting into an actual final hearing or a trial. That period of time on the low end, let's say 6 months. On the high end, it can be several years. The sooner that you're able to settle the case, the better. That's less time and less money that you're having to spend involved in a lawsuit. Which brings me to the second point, which is money. Remember, your lawyers are probably billing by the hour, and those fees are going to add up over time. If they have to go and can prepare for a contested hearing, they're going to go through discovery, which is where they have to ask questions to each other, do depositions, produce documents. They're going to have to prepare witnesses. They're going to have to do all sorts of trial preparations, which will cost thousands of dollars. By settling, you avoid having to deal with that process. Also, relationships. When you go to a contested hearing or a trial, most likely when people leave those, whoever's on the other side, that relationship tends to be pretty faulty afterwards. And it can be very sad, and especially in family law cases where you're dealing with your ex-husband or ex-wife or your child that might be at issue. The chance that you're able to salvage a relationship is fairly low after you go to a contested hearing. Also, with respect to outcome, when you go to a hearing, obviously, it's a toss-up. You might know that you have a strong case or think you have a strong case. People statistically tend to overestimate the strength of their cases and underestimate the strengths of their opponent's cases. But when you go to trial, you're not making the decision. You don't really have much control over the decision. You're letting someone else make the decision. And that puts you in it's not a position of power, that puts you in a position where you have very little power to actually decide what happens with your money or your kid or your house or whatever might be at issue. So with respect to settlement lets you be in a position of power where you get to decide what terms you're okay with and what terms you can live with and what you're not okay with. When you go to court, again, the power is gone. The judge has the power. So let's say that you have an awesome case and you go in, you have a great story, and you go up to the stand, you tell your story about how you're this awesome parent and that you have, these concerns with respect to the other parent. And the judge listens to all of it, and your lawyer asks questions, and you do really well, and the other side asks questions, and it looks like they didn't really tear apart your testimony. The judge at the end can say, well, that was all great, but I don't find you credible. I don't believe you. And then all that great testimony didn't really do much. It wasn't that effective. That happens, and it happens all the time. And a finding by a court that you just aren't credible isn't really something you can appeal. There isn't a process to say, I just don't like that the judge thought I was lying, or I don't like that the judge just thought that I was a bad parent. That's not an appealable issue. You've given up all of your power, and now you're here, a judge has made a decision against you, and there's not much you can do about it. With settlement, again, you have power. You can come up with creative plans. You can come up with, whether it be a parenting plan, or you're trying to settle an estate, or you're trying to settle a divorce. You can come up with really whatever provisions you want to propose. And there oftentimes is a lot of this uncharted water and territory that people just don't think about that actually could assist in settlement. You can come up with compromises you wouldn't have been able to get when you actually go before a judge. So if you go before a judge or a jury in some cases, you're not going to get this detailed order that, or I should say rarely you're going to get a detailed order that's going to take into account all the different factors that you talked about on the stand. Judges are busy, courts are busy, and they might give you a 2-page order that addresses kind of the main points. It addresses at least what has to be addressed. When you go and you decide to settle, you can talk about all these finer points that might be really important to you that the judge just might not find to be that important. They're just not that big of a deal, or they're not really legal issues. They're more just things that you want that the other side might be happy to do. You can find that out in a settlement. You can come up with, and I often have, a detailed 10 or 20-page agreement that goes over every single thing that might be important to you. Again, it's not going to happen when you go to court and leave that issue up to a judge. Let's see. So, when you're actually going to court and you're taking the power of settlement out of the equation, the judge is going to, listen to you for a couple hours. You're probably going to get, if it's a final hearing, a half-day hearing typically. So there's 3 hours, including the breaks and the time the judge needs to make the ruling if they're going to give an oral ruling. You got 3 hours between two sides, so an hour and a half apiece. That's all the time the judge is going to have to get to know you, your kids, the case, whatever might be going on. It's not a lot of time. It's not a lot of time at all. And as a result, I will say that clients tend to walk away happier from settlement, knowing that they've made some concessions, they've gotten mostly, what they really want, they can live with it. And instead of walking away from someone who had a full, 4 hours perhaps to get to know their case and know them and know what's going on, and then they're in this position where they have to make a decision, and the judges do the best they can with the time they're given and what's presented to them, but their information is fairly limited. And a lot of money later, you've gone to a hearing, you've gotten to your half hour on the stand, and you're hoping that they believe you. Having an agreement that actually reflects what you want is a far more powerful place to be. So there's this connotation somehow with settlement that it's a position of weakness, and that lawyers need to be going into hearing, and they have to be aggressive and they have to be strong and whatever. And trust me, there are times that that's appropriate. The times that's appropriate are when usually it comes when lawyers or just individuals that are pro se don't understand the law, they understand the strengths of their case, they understand the weaknesses of their case, so they need to go try that issue. They need to actually go bring it before a court. But when you have good lawyers, or when you have smart parties on both sides that can say, look, I know this is a strength in my case, I know this is a weakness in my case, this is where I should concede, this is where I should not concede, they come to agreements. But settling doesn't happen out of weakness. Settling happens out of knowing your case, knowing your strengths, knowing your weaknesses, and being able to come to the table and have an honest discussion about what should happen in your case and being able to make a decision that's going to be probably much better informed than the decision that the judge is going to make. It's a position of strength. So if you're in a family law type of dispute, certainly, I would encourage you to explore settlement and take settlement very, very seriously, because you have a much higher chance of getting a result that you like, that you can live with, that your family can live with, that your kids can live with for a long time, than leaving the issue up to a court because you don't fully understand the strengths and weaknesses of your case and the strengths and weaknesses of the other side's case. So again, I'm Laurence Gendelman with Gendelman Law Group. You should follow us on Twitter, Facebook, YouTube. Our handle is Gendelman Law on all three of those, and Instagram as well. I hope to do some more presentations soon, and until then, have a nice day.